May I please, Lord?
Yes.
I beg to mention, my Lord, item number 47,
47.
supplementary hearing, but my file is somewhere misplaced, so I'm not here today, so sometime may be given, my Lord.
Consent from the other side.
Yes, yes, other said, I have
Okay.
taken consent.
Mr. U. Deka Learned Counsel for the appellant submits that he has misplaced his brief,
Yes, 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 for reconstruction of the file.
for which he prays for 3 weeks' time to reconstruct his brief. List of where the consent has already been taken. Consent on the consent, the consent has been taken from the
Yes, my Lord. Yes.
other side. Mr. Praise the Lord. List this matter after
Briefly.
3 weeks. Yes.
Your Lordship, I beg to mention item number 12 on behalf of T Mind. He is for respondent number 2.
Item number
12.
12.
Yes, I have taken consent from the other side. Matter may be adjourned today. And,
You are for
respondent number 2.
on the prayer of MS Learned Counsel appearing for resolution number 2, and on the consent of
I'm for the
Learned
petitioner.
Counsel for the petitioner. List this matter after
Your
3
Lord-
weeks.
Yes, Your Lordship.
Your Lordship, there is an interim. That
Interim
may be
order
continued.
passed earlier shall continue.
Obliged.
Lordship.
My lord, I beg to mention item number 11,
Yes,
maybe agent for the
you are for
respondent.
on the prayer of Mr. So-and-so Learned Counsel appearing for respondent. List this matter after 3 weeks.
And also one more item number
Item number
46.
46.
Yes, yes. Here I am for the petitioner.
Why? I think sentence is of 3 years,
Yes, sir.
2021.
Today the matter was fixed for hearing. We will do in the next. We will present in the next hearing.
Are you in the jail? Are you in the jail?
I'm not aware about the facts and circumstances of the case. I've been just instructed to.
We'll see. You get the instruction right now. We'll see. See, the sentence is of 3 years. It was in somewhere in 2021 February. 3 years complete. If you are on bail, it is something different. Find out. We'll take it up.
Please, Your Lordship. I beg to mention item number 52 and 53 on behalf of Mr. D. Soki.
50?
52 and 53
Yes.
on behalf of Mr. D. Soki, Your Lordship. My Lord, Mr. Soki is out of station. May the matter be fixed after 3 weeks, Your Lordship.
He is for
He's in item number 53, he's for the petitioner. In item number 52, he's for the respondent number 2.
Ms. D. Tamuk, Learned Counsel, appearing on behalf of Mr. D. Soki, Learned Counsel for appellant in
Item number 53.
criminal appeal number 18 of 2022 and respondent number
2.
2 in criminal appeal number 19 of 2022. Praise for listing the matter after
3 weeks, Your Lord.
3 weeks.
My
Praise the
Lord,
Lord, list this matter after 3 weeks.
my Lord, there is an interim order in item number 53. It may be continued.
What interim order?
I'm not aware of the facts. I've been informed that there is an
Criminal appeal.
Yes, Your Lordship.
Either it should be there must be bail or accused must be on bail or
Yes, Your Lordship. The interim order will be suspension of the sentence, so it's not required to be continued. It will be continued till the culmination of the appeal.
is it
Yes, Your Lordship.
suspension of order so and so shall continue.
Much obliged. Your Lordship.
Mayor, please. No, under item number 27 and 28.
27 and 28.
So I would like to mention
Yes.
on behalf of respondent number 5 and 6, private respondent number 5 and 6.
Mr.
HR Obing,
HR
Lady
Obing.
Council, yes.
You are HR Obing, no? You are not HR Obing.
No, on behalf of HR. Yes.
Mr. So and so, your name please?
B. Taka,
B. Taka,
yes.
Learned Counsel appearing on behalf of Mr. HR Obing, Learned Counsel for the respondent,
Yes.
private respondent.
Private respondent number 5 and 6.
Huh? Okay, then 27, 28, 29, 30.
No, actually, yes, only in under this 27 and 28, I have.
No, it's connected,
I-
listed together.
Yes, I on behalf of Subbu Koya. So,
You don't
I
have any objection.
no,
Okay.
No,
and
Then in that case, on the joint prayer of learned council for the parties, list this matter after 4 weeks. Item 27 to 30.
obliged.
Yes.
May I? Your Lordship, I beg to mention an unlisted matter. IA in criminal petition 6 of 2024,
Tomorrow,
In- tomorrow. And there's another matter, the similar matter, I mean, say, a criminal petition of number 43 of 2020.
Day after tomorrow.
Oh,
Tomorrow and day after tomorrow.
okay, thank you. Deeply obliged. Lordship, I beg to mention item number 7.
7.
Yes, on behalf of El Perme, for the petitioner,
Mr.
S. Zirang.
Huh?
S. Zirang.
S. Yang learned counsel appearing on behalf of Mr. L. Perme, learned counsel for the petitioner. Praise for listing the matter after 3 weeks.
Yes, Lordship.
Prayers allowed list after 3 weeks.
And Lordship, item number 41.
41.
Yes.
Yes.
This matter may be also taken up after 3 weeks.
You are for
For petitioner on behalf of El Perme.
41.
Yes, 41.
Okay. Same order, huh? 41.
Lordship, interim order that may be
Interim order process. Let's say continue. Yes.
highly obliged.
Lordship, I'd like to mention item number 14.
14.
Yes, Lordship.
Hmm.
In this case, there is interim order may be continued. So some more time may be given to file an additional affidavit. 3 weeks may be given.
You are for
I am on behalf of Mr. G. Talo.
Mr. So-and-so learned counsel appearing on behalf of G. Talo, learned counsel for the petitioner. Praise for 3 weeks time to file additional affidavit.
Yes.
Praise allowed list after 3 weeks.
Lordship, interim order.
Interim order for earlier shall continue.
Lordship, again, I'd like to mention item number 35.
35.
Yes, Your Honor.
Hmm.
Lordship, this matter will be fixed after 3 weeks. Moreover, the LCR has been received. So this matter will be fixed for an admission.
We'll see. It's order is this. You be there. What is to be done? We'll see.
Yeah, substantial of question law has been framed, my lord.
Okay.
And in IS,
Why this has been listed today?
maybe to confirm the LCR, my lord. So LCR, it's received, my lord. So matter may be admission hearing, my lord. That's it.
We'll see. Wait for your turn.
Yes. Highly obliged.
So for this item number 46, my lord.
Yes.
My lord, since this is a criminal appeal, my lord. My lord, I need some time for preparation, my lord, because my lord,
No, I just wanted to know what happened to this sentences of
sentence, my lord,
3 years.
this has been suspended, my lord.
Suspended.
Suspended.
That's the reason I.
No, my lord.
That is precisely I wanted to know.
Because my lord, at a time, my lord,
Otherwise, nobody will ask for adjournment when the man is in jail and the sentence is over.
my lord. But still, my lord, I will put my best to get it disposed of.
46.
But some fixed date, my lord, I will just
46.
take, my lord.
On the prayer of Mr. Arsenal learned counsel for the petitioner. Appellant. List this matter after
Well, can it be on June 6, my lord? June 6. June
after
6,
3 weeks.
my lord.
4 weeks.
4 weeks. Oh. Deeply.
Your
Yes.
Lordship, I beg to mention item number 15.
Yes.
I'm for the petitioner and I'm appearing on behalf of leading counsel T. Sunil.
Hmm.
Your Lordship, I was supposed to file an affidavit in reply. However, I have not received the certificate from the concerned department. So this matter may be listed on this Tuesday. That is on 15th of May.
What affidavit in reply? It's a criminal petition.
Yes, Your Lordship, I was supposed to indicating the breakup of the amount of rupees 7 crore 31 lakhs 13,991
Hmm.
is received asked from the
Did you-
Itanagar Municipal Corporation.
Petitioner,
Yes, your
Of
lordship,
petitioner.
yes,
MS so learned counsel appearing on behalf of Mr. T. Sunil,
yes, your lordship.
learned counsel for the petitioner. Press for and is granted 3 weeks time to,
No, your lordship, it may be fixed on this 14th of May.
what's the auspicious occasion on 14? I believe it's not 14 February,
14th of May, your lordship.
14 of May,
Yes,
after a week. After a week,
and your lordship, one more item number is there.
yes,
Item number 34.
34.
On behalf of B.R. Das. This matter may be listed after 3 weeks.
It's order, we'll see, you be there.
Yes,
You wait
your
for your turn, we'll see.
Your lordship, I'm just instructed to ask for the next date only. He's from Guwahati.
You read the file and you be with there. Give her the file, item 34.
Deeply obliged.
My lordship, I beg to mention item number 48.
14,
Yeah, 48.
48.
Yes, your lordship. Seeking for adjournment on the ground that the leading counsel is feeling unwell. We have taken the consent of the opposite counsel as well.
Therefore,
Petitioner
Mr.
M. Tangjong.
Mr. So-and-so, learned counsel appearing on behalf of Mr. P. Tamin.
G.
Or G.
Kato.
Kato,
G.
G.
Kato.
Kato, learned counsel for the petitioner. Press for listing the matter after 3 weeks. Press or list this matter after 3 weeks.
Much obliged, sir.
Yes, sir.
My lordship, I beg to mention item number 17.
17. Yes,
The matter may be adjourned for today and fixed for after,
therefore,
on behalf of petitioner, Bitaba. Petitioner,
we'll see. We'll see. Do you have the brief?
no lordship.
You give him the second copy. Take the second copy and read it. We'll see what is doing.
Which I beg to mention item number 19.
19.
Much obliged.
Consent from other side. On behalf of Itabu, Standing Council for Education.
On the prayer of Mr. On the prayer made on behalf of Mr. T. Tagop, learned counsel for the petitioner, the respondent, list this matter after 3 weeks.
3 weeks.
Be pleased, your
Yes,
lordship.
sir.
Bail application under section 459. The accused was arrested on 31st January 2014. So today,
NDPS,
NDPS, my lord, that's
heard Mr.
small quantity, my lord.
Mr. Udeka, learned counsel for the petitioner. This is an application under section 439 CRPC, 1974, for grant of bail to the accused person in connection with Bandadua PS case number 45 of 2024. Under section 21 within bracket small bracket close of NDPS 1985. Call for the case.
C3.
Call for the case.
Yes, that.
List after 10 days. List after 2 weeks.
1 week. sir.
List after a week.
Yes. Obliged.
Sir,
Yes.
are you all right? Yesterday, this court was informed that you are not you are not well.
Yeah.
Today you are well. Yes,
This criminal petition has been filed under 482 of the CRPC. By way of challenging the order.
yes, where is the order? Where is the impugn order?
Yes, executive order.
Where it
that
is?
Page 18,
18, yes.
and till page 18 to page 22. 22,
22?
made series of orders
Yes,
amongst to the petitioner.
The order is that whereas a written report has been received from DLRSO alleging that you have illegally encroached, occupied and constructed structure at golf lane within the premises of GTC playground of Pasigat Township. Whereas GTC playground is necessary public space for games and sports, and such blatant encroachment of government land area is outrightly illegal and is punishable under law. And whereas claiming back government land through flimsy claims of ancestral land is gross injustice and is a very shameful act. And going by this misconceived argument of claiming back ancestral land, all district headquarters and majority of the state land will be claimed by outsider, which cannot be allowed. Whereas there has also been reports by physical violence between some clan members over claims of ancestral property over GTC playground. Whereas it is felt that that there is need for restriction of all types of encroachment and construction of any structure in the aforementioned area and to remove evict any structure within the enclosed area within
Yes.
7 days. Yes. Now, on the basis of this, and therefore the greater interest to maintain the public order, I, Tai Tagu District Magistrate, East Siang District, Pasigat, in exercise of the power conferred upon me under Section 133 CRPC, do hereby prohibit all types of construction and to remove evict any structure, and you were hereby directed to remove all the structure and mark within 7 days of issue of this notice. Failing to do so will attract appropriate provisions of law and also be penalty rent for dumping mark on government land will be levied upon you as per law. Now, she has invoked Section 133 of the CRPC. Before invoking of Section 133 of CRPC, there is a procedure laid down in Section 138 of the CRPC. Now, as per Section 138 of the CRPC, that they should issue a show cause notice. At the same time, they should record the statement before the magistrate or before the executive magistrate. But here in the case, there was no show cause notice and no evidence was taken. So he cannot directly pass without following the procedure of Section 38. They cannot pass any order
Yes.
under Section 133 of the CRPC.
Yes, Your Lordship, I have a preliminary objection regarding the maintainability, Your Lordship. Why? Because, Your Lordship, my learned senior counsel has invoked the provision of 482, which can be invoked in the circumstances when the interlocutory order, no interference of the interlocutory order will amounting to abuse of process. For securing ends of justice, 482 can be no doubt can be invoked. However, this order is a final order. If final order is there, Your Lordship, then revision lies, Your Lordship, under Section 397. And Your Lordship, in their statement itself in para 12, it clearly reflected that this order is a final order, Your Lordship. If it is a final order, then revision lies, Your Lordship, not the inherent power of the Honorable High Court under 482.
Now, when they do a pass on order, first they should follow entirety of the procedure of the law. When the order has been passed,
But the remedy,
and it seems to be of-
remedy lies somewhere else.
Huh?
No, remedy lies. There is a provision for your remedy. Not
No.
482.
482,
He said it's not maintainable. At best, you can approach under 397.
Yes.
it will not be revision. It will not be a revision.
Why?
Because when order has been passed, an order, if any order has been passed without following the procedure, so in that case, it never lies revision, but it should be quashed. And in supporting, I will show you the rulings.
We can,
Yes,
we can,
yes. Now, now to the-
we can say, set aside the order under revisional jurisdiction too.
come to the para 4. In our opinion, the omission on the part of the subdivisional magistrate to draw up a preliminary order, which is a sine qua non for initiating proceeding under section 133 of the Code of Criminal Procedure, and without following the procedure provided for by section 138, the order made by the subdivisional magistrate on 1988 is unsustainable and is vitiated. The High Court fell in error in not properly appreciating the effect of non-compliance with the mandatory requirement of drawing up a preliminary order before proceeding under section 133 CRPC. Neither the order of the High Court nor that of the subdivisional magistrate can therefore be sustained. So here in the case, that they have completely passed over the section 38 of the CRPC, and to invoke this 133, they should follow entirety of the section 138. Moreover, a case is pending before the senior division civil judge. That is in para 20, I have reflected in my petition, para 20. And annexer 5, page 33. A civil case is pending before the senior divisions, civil judge.
No, you may be correct, but then
And now the thing is that when a matter is pending before a civil court, in that case, the executive magistrate has no power to pass such order.
what is difficulty in filing the petition under 397?
And in the meantime, para 20 of my petition.
Your Lordship, so far as the merit is concerned, Your Lordship, no doubt, Your Lordship, to initiate and proceeding under section 133.
There's parenthesis, there's a.
Yes, the procedure has under 130 days.
Please notice, call for the records and we'll keep the maintainability issue open and in the meantime we'll list it.
Your Lordship,
Parenthesis,
Your Lordship may kindly,
there's a violation.
I would like to rely, Your Lordship, regarding the order or interlocutory and the final order, Your Lordship,
Okay,
when,
we'll say that. We'll decide on next day. Right. Not Mr. M. Pratik, learned counsel for the petitioner. The filing this application under section 482 of CRPC. The petitioners have challenged the executive order dated 30/04/2024. Same order,
Same order.
same day.
In all the petitioners, they have served different.
How
In a-
many petitions?
Five,
4 orders.
five order,
There are 4 orders only. 5 orders, huh?
five.
Challenge the executive order that it. The 5 numbers of executive orders, impugn executive orders, dated 30/04/2024. Issued by the district magistrate, East Siang District, against the petitioners in a purported exercise of the power conferred upon under section 133 CRPC, whereby prohibits all types of construction and to remove or evict any structure and directed to remove all structure and mark within 7 days. Dwelling which appropriate provisions of law shall be invoked against the petitioners. Issue notice returnable by 2 weeks. Mr. P. Learned Additional PP enters appearance on behalf of.
respond number 1.
You are not appearing for district magistrate.
No, Your Lordship.
For respond number 1.
Your Lordship, my submission regarding maintainability may be recorded, Your Lordship.
No formal notice need be served. However, extra copies be furnished to the learned counsel for the petition. The additional public prosecutor. Steps be taken for respond number 2 within 3 days. The registered post with addition within 3 days, huh? For respond number 2. Mr. M. Pratik, the counsel for the petitioner, submits that the impugned orders have been issued to the there being any report from the police officer or other information or without taking any such evidence. Therefore, he submits that the orders are in violation of violation of the provision of the section 133 of CRPC. Because in such the same may be questioned by invoking the power of this court under section 482 of CRPC. On the other hand, Mr. T. Learned Edison to submits that the present petition is not maintainable in view of the fact that the
Order is a final
orders
order.
are-
Order is a final order.
orders issued, the impugned orders issued by the executive, a district magistrate is a final order. If at all the petitioners are agreed, he may approve by filing petition under section
397.
397 of CRPC. Next page. Having considered the submissions and also considering that prima facie the impugned orders passed by the executive district magistrate, East District, appears to be not in accordance with the requirement of the provisions of 133 CRPC. In the interim, the impugned orders that is so and so, so and so. I deem it appropriate to stay the impugned orders so and so, so and so, accordingly, so and so, so and so. In the interim, the impugned orders are stayed till returnable day. The issue raised by the learned additional people with regard to the maintenance shall be kept open and same shall be deliberated on the next date,
Yes. Deeply obliged. Your Lordship.
just after 3 weeks. Yes.
May I please, Lordship?
Any live issue, surviving issue?
Exactly, that is what I'm trying to get back to my client.
Yes,
All of them are happy where they are.
yes.
Live
Live and let live.
Leave and let live.
Your Lordship,
Senior counsel Mujumdar was
Conduct
appearing
conduct-
for private respondent number 7. Today is voting day in Assam, Guwahati. So he could not
Will
make it.
will it have some bearing in your retirement?
No, my lord,
I
exactly
mean,
not.
the retirement benefits in the retirement.
No, except or otherwise for the seniority purpose only. Because the
No, that's what I'm saying.
private respondent number, initially
They
he
might
was,
be on the verge of retirement.
all of them, my lord. Let me come back, my lord, after 3 weeks,
Okay.
I'll come back.
On the joint prayer of learned counsel for the petitioner, Mr. T.T. Tara, learned counsel for the petitioner in writ petition 259 of 2014, and Mr.
K. Tabang.
K. Taban, learned counsel, appearing on behalf of Mr. D. Majumdar,
D. Majumdar, Lordship.
learned senior counsel for writ petition 30 of 2014, and Mr. T. Tagum for standing counsel for health department. The matters are adjourned for another further 3 weeks. For a further 3 weeks. This after 3 weeks.
Deeply obliged.
Yes, state. You're supposed to file a counter affidavit.
Item number 6, Your Lordship. Your Lordship, this matter may be listed after 2 weeks, Your Lordship. Senior government advocate S. Taffin is appearing.
on the prayer of MS P. Pangu, Learned State Council, list this matter after 3 weeks. Registry to issue notice to the petitioner as the Learned Council for the petitioner on being accepted the NOC by the petitioner as withdrawn from the case. Huh?
Nice, Your Lordship.
This before any other bench without me.
Correct, Lord.
I think I've appeared the related matter.
Right, right.
Number 9. Lordship, in
Yes.
yes, in this matter relating to ex gratia, my lord, but Union of India is the party, but yet not file affidavit in opposition.
What is the affidavit on behalf of the state?
Lordship, according to this, he is not eligible because it was
He or she?
he is.
See, yes. The petitioner is
Martyr is he.
yes.
Not eligible because
Obviously, she is no longer in this world. He will not be
no,
eligible.
Lordship, she is not eligible
His
because
widow will be eligible.
no, widow is not eligible because this notification was published in 2017 and he died 10 years earlier.
Who has to pay? Is
State
the
has
state,
also.
or, state or the union of
There
India?
is state is also eligible, Lordship, according to that.
Where it is?
He was army Assam regiment
Yes, I've seen it.
while he was confronting with the militant, Khalistani militant.
Yes, yes, I've
He
seen
died on guns.
it. Where it is? Where is the policy?
The policy is. Lordship, at page 41 in their affidavit.
41 or 7? Filed by
No,
respondent.
no, Lordship, in the petition.
Hmm. Yes.
My lord, I may be allowed to file rejoinder in this state affidavit.
You have taken time last time also.
Oh, yes, sir. Sorry, my lord, extremely sorry. I could not prepare due to the petitioner is away from here at Longding. So in this time, I will certainly submit, my lord, rejoinder because some earlier notification was not mentioned in the state affidavit, my lord.
Why you are saying it's not applicable?
Because this policy started in 2017
Yes.
and the person died in 2000.
1992.
So 1992. So this will be applicable prospective only.
Prior to this, also some notification was published by the governor of Arunachal Pradesh and Indian state. My lord, even if a person is dying naturally also, unnatural death, then also the state government allowed 3 lakh rupees ex gratia. But here it's a sacrifice, but Surya Sakra holder is a gallantry of the victim.
No, this is 41 is for police personnel. Civil police, armed police, battalion, IRBN. Under what provision? What is is there other policy?
Under
No, see, 41, part 1, 2, C, Lordship.
2C.
Objectives 2C.
To provide excuse when to permanent residents or not Pradesh central forest. Oh, okay, I'm pursuing who got killed. Yes, it said who got killed, permanently disabled, previously injured in encounter with militants. Who got killed?
The husband of the petitioner.
Yes, it said you read this, see,
No, Lordship,
subclause C.
but this policy, it's that is applicable in the year 2017.
That's why I'm saying you read it. See, closely you read it. Read it loudly. Let us understand.
To provide ex gratia grant to permanent residents of Arunachal Pradesh employed in the Central Paramilitary Forces, Armed Forces of the Union of India who got killed permanently, disabled or previously seriously injured in encounter with militants, counter-insurgency operations, border skirmishes, war.
Yes, it says who got killed.
That is why the notification, it will be applicable from 2017 only.
No, it doesn't say, when you say read this who got killed, it doesn't say, it doesn't indicate only prospective.
My lord.
Am I wrong?
This was adopted in 2017.
No matter. It's your language only.
But affidavit also specific on that.
Who has filed the affidavit? Is it by the chief secretary?
No.
Yes. Has he read this sentence? Whether it will be prospective from 2017. You may be correct. So as have you submitted any documents to the deputy commissioner
Yes, my lord. The
on
deputy
the basis
commissioner,
of this policy,
yes, yes,
this notification?
this notification, the the commissioner along with a committee submitted the report to the secretary of the state government of Assam. Oh, sorry, state government of Arunachal Pradesh, my lord.
Yes, sir.
Actually, if a person dies, it will be always address as killed only.
What about got GOT?
So that's why who got killed.
Yes.
If a person dies tomorrow, somebody claims on behalf, he's already dead.
You show us anything to say that it's prospective. It will apply prospective. I don't find anything except this who got killed. What is your stand?
Our stand is basically the employee of the state government.
No, it's not employee. It's the army.
Army, my lord.
Who got killed while fighting Khalistan.
Khalistan, yes.
As per this, I'm sorry, as per this, this is not that clear.
See, the widow, the petitioner has got something that point of time. But now it's, yes, that has been given. That's why I want your stand. She got something that point of time. And she's getting 45 per month.
Yes.
Some, what do we call it? 45,000
What do you,
per month. What is called it? What do we call it?
pension only,
Pension.
pension, family pension.
That is from the government.
On the occasion of the 70th Independence Day celebration, the Honorable Chief Minister has announced that the state government will prepare a policy for about the next Asia Telecom 15 days. Only to the extent the police prosecution with respect to rape who died while fighting any terrorist, criminal, underground elements, or while performing law and order duties and force, and also for providing specific government jobs of the so this is obviously while fighting violence.
It's okay. We'll catch hold of him about this. I want your stand. You file an affidavit, right? If you have given as per the Union of India, whatever she was entitled. I've seen it, I think you have provided, Army side, Union of India, they have already provided.
Yes.
Some 1.5 lakhs, this
Right,
expression,
right, man.
and then retired benefits of 45,000 per month. So it's you now. Claim is against you now. It's a policy for the welfare of the armed forces. You should construe it liberally.
You can understand. The claim is
Heard,
also-
Mr. You declare consent for the petitioner.
claim is also after 20 years.
Doesn't matter. For the petitioner, I wanted to dispose of the matter. You want to file an affidavit in opposition. What can I do? Who prays for listing the matter? Who prays for 3 weeks time to file affidavit in reply? Mr. I did a London additional senior government advocate submits that. Referring to the policy notification dated 24/04/2017 submits that the policy of the state is is applied prospectively. Therefore, the petitioners, only one.
Only one
No,
sole
the
petition.
petitioner is not entitled for any ex gratia grant under the said policy. Said notification. Mr. On perusal of the policy of the state has notified on 24/04/2017. Come on, this court is of the prime view that the language used in the policy, a policy being a welfare measure, appears to be may be applied to the case of the petitioner. Mr. Howard, since the learned counsel for the petitioner has sought for a time to file objection, file affidavit in reply. That is adjourned for another 3 weeks for further deliberation. It's my prime view.
Number 10.
Yes, madam. What is this?
My lord, the petitioner is challenging the action of the Deputy Commissioner, Your Lordship, in dismissing the petitioner from the post of Gaongbura, Your Lordship, without giving the petitioner an opportunity.
There's no village now. How can you be allowed to continue as a government?
My lord, the village is still in existence, Your Lordship. However, the place,
Apply for the new village.
no, my lord,
The village where you were appointed
my lord,
as a Gaongbura
Yes,
is
your
no
lord.
longer there.
my lord, the
What do
only,
you say? Am I right?
no, Your Lordship. Only since there was a lack of communication for,
You
Uh,
have shifted to other village.
no, we have shifted to a
All
community.
the villages.
No, though, we have shifted to a community place that belonged to the, earlier belonged to the
What
village.
happened to that village?
That village
Is no longer there.
it
You
has
have
been shifted
abandoned
to
that
another place,
area.
Your Lordship.
What is the new village?
That is, Charu only, Your Lordship.
You file an application
That is,
that we have all of have shifted to new place called this. So
No,
I
my
should
lord,
be
the-
allowed to
even
continue.
the name of the village is same, Your Lordship. We have shifted
Same.
to, yes, Your Lordship.
Okay.
It
Let
was-
us see the order. He should be allowed to continue. No, he has left the village, old village, where he was appointed as a Gaongbura, according to you. And he is shifted to new village. It's common sense, according to common sense. Third, MS D. Tamuk, Learned Council for the petition. MSP Pango, Learned State Council is granted 3 weeks time to file affidavit in opposition. Are you continuing?
Yes, Your Lordship, there is a stay.
There is stay. There is stay.
There's yes. Interim order.
There is a stay.
Yes, Your
Interim order.
Lordship. There's an interim order.
Interim order, therefore, still continue.
Much obliged.
Item number 13.
Lordship, in item number 13, I would like to file an additional affidavit.
Yes.
The charge has been framed and the section 307 and 27 of Arm Act has been dropped. So in effect to that, I'll file an additional affidavit.
Additional.
Yes, sir.
Mr. B. Jamal, Learned Counsel for the petitioner. Press for it is granted 3 weeks time to file affidavit in additional affidavit.
Yes, Lordship. Deeply obliged.
Mr.
Item number 15.
Yes.
After this, we was called for,
Hmm.
and we were by sending domestic affairs.
You are yet to receive that.
Therefore,
You are not received. Third, Mr. Yes. Yes,
Thereafter, on 24/4/24,
yes,
and it's being called from Meekyong, Upper Siang district.
yes,
It's not verified. It shouldn't take such a long time, Lordship.
yes. So what is to be done?
Next step may be.
The short date, Lordship.
Or Miss MS Arthak, Learned Counsel for the petitioner. Also have MS Endagel, Learned Counsel, appearing for
2 and 3.
Correspondent number 2 and 3. The matter was, this matter has been adjourned for want of updated case diary. Today also Mr. Jitado, submits that he is yet to receive the updated case diary. In view of the Learned Council, Learned additional PP is directed to obtain the status, what is called is updated case diary produced before this court within a period of 1 week. List after a week.
Lordship,
10 days.
fixed date may be given.
10 days, huh?
Fixed date, Lordship.
10 days, huh? You choose the date.
15, say,
15, 16,
this
16.
16, your lordship, there would be difficulty because my senior, he will not be in this.
Huh?
16 would be difficulty, your lordship.
Why?
The leading counsel, he would be out of
You
state.
be here, you argue the method. You are competent enough.
That is there. If
Everyone is competent, no worry.
that is there, your lordship, otherwise, 2 weeks time, if it
15.
is given, your lordship.
15.
Otherwise, after 60, on 21st, your lordship, if it is, okay.
You are not interested to argue the method before.
No,
this
no,
court.
your lordship, if I'm given the opportunity, but as of now, 21, if this matter if it can be listed on 21st.
See, he's praying for 21.
21 minutes.
It's okay. 21.
Much obliged.
Yes, sir. What is the matter?
My lord, actually the leading counsel is, my lord.
That's why I have given you the chance to argue the matter. Argue. Tell us the facts.
Academy. My lord, filing for, as per the additional affidavit filed by respondent 3 and 4, we'll find on next date.
No, what is the matter?
Matter is, my lord, regarding
Have you
the
gone through the-
compensation.
Petition. Read the synopsis loudly. Yes, who appears for the state? Sir, when did you join the bar? Huh? Okay. When was synopsis in the second file? Huh? You take this file.
My lord, yes.
Use the mic
The petitioner is a local resident.
and open up.
The petitioner is a local resident who has an ancestral private land measuring about 3,000 square meter, which is situated at Ramsing village. On the said land, he used to farm orange plant, tokopata plants, tasat plants, bamboo plants, betel nut plants, and other seasonal fruits also. By selling those, he earned a hefty amount and ran his family. In the said land, there was a boundary wall which was erected by his father in the year 1995 for protection of the crops and trees. However, at the time of extension of the roads from Boirung Bridge to Ramsing village in Upper Siang district, the construction agency under the PWD, Yungkyong, fully damaged his boundary wall without the due process of law as per the provisions of relevant laws. That the said boundary wall was covered and protected the petitioner's fruits, vegetables, and trees from any kind of outside trespass, either from human or cattle of the locality. Prior to the extension of the said road, the petitioner informed through a letter to the office of the Chief Executive Engineer, PWD Yingkyong, not to trespass his land by damaging his boundary wall, but the said construction agency had damaged the boundary wall in the name of extension of the PWD road. Thereafter, the petitioner on various occasions for the last 2 years submitted representation after the representation before the Deputy Commissioner Upper Siang District to conduct an inquiry of his damage and also to compensate his loss for the illegal action of the respondent authority. After receiving the representation from the petitioner, the Deputy Commissioner Upper Siang passed an order on 19/5/2022 to the Extra Assistant Commissioner to conduct an inquiry for the complaint which had raised by the petitioner. But for the utter surprise, still that the concerned authority neither conduct any inquiry nor pay any compensation to the petitioner, as he has suffered heavy loss after damaging his boundary wall in his ancestral landed property at Ramsing village. Hence this petition.
Yes. What you have understood? What is your case?
My lord, actually, I have not got the full knowledge detail of this case. Just the senior has instructed me for the matter for the adjournment today because he has not filed the affidavit in reply also, and is moreover
your
out of
senior?
his Bitaba.
Huh?
Bitaba.
Yes, madam.
Father Lordship seeks some more time for filing an
Lordship,
affidavit.
after receiving his complaint, Your Lordship, EAC has directed the PI, Your Lordship, to conduct inquiry and to verify the complaint received by the petitioner. But it seems like, Your Lordship, petitioner is not cooperating, Your Lordship.
Yes,
I have filed my additional affidavit, Your Lordship,
yes.
at page 5, Your Lordship. Inquiry report by the head Gaon Bura.
Where it is?
Additional affidavit, page 5. Additional affidavit by respondent number 4,
Yes.
page 5, Your Lordship.
Hmm.
Report
Yes.
by the head Gauburas to the EAC, Your Lordship. As per order mentioned above, the subject issued by the office, I tried many a times to inquire, verify the
Where it
complaint.
is? Where it is?
Page 5, Your Lordship.
Para?
Para 1, Your Lordship. It's a letter to the EAC.
Para 1.
It's a letter. Page 5.
Something wrong. Okay.
It's an additional affidavit, Your Lordship. Page 5.
There are 2 additional affidavits. Yes. Hmm.
Additional. Page 5, Your Lordship.
Hmm. Hmm.
Letter to the EAC, Your Lordship.
Hmm.
As per order mentioned above, the subject issued by the office, I tried many a times to inquire, verify the complaint received from Shri Agur Nangu of Ramsing village, but he did not respond me and making excuses of not being present in the station. This is for your kind information to the office, as you have directed me to inquire the matter by 28/3/2023, and this is the final report submitted by me regarding the order issued by the office, Your Lordship. Inquiry, Lordship, could not be done, Your Lordship, because of non-cooperation of by the petitioner, Your Lordship.
Not Mr.
My lord.
Your name, please.
Ekabak.
Appearing on behalf of, appearing for the petitioner. Next para. MS R. Basar, Learned Assistant Counsel, referring to the additional affidavit filed on behalf of the respondent number 4. Submits that. for for verification and inquiry of the complaint from the petitioner. The public, what is called political interpreter
Yes.
of Jengen Circle was deployed. However, the petitioner is not cooperating for such inquiry. Therefore, the inquiry could not be conducted. Considering the above submission, the learned counsel for the petitioner is directed to obtain necessary instruction. If no instruction is placed on the, in the event of failure to place on record the instruction in view of the report submitted by the PAI Jengen Circle to the Extradition Commission, the writ petition shall be closed as the prayer, as the grievance of the petitioner is for an inquiry, is for causing an inquiry or verification of his complaint. Understood?
Yes, my lord.
You have received the additional affidavit.
Yes, my lord.
They want to make an inquiry and verify your complaint, on your complaint. You are not cooperating. What can we do? So on next day, you take your you obtain the instruction and place before this court. If you don't place it, this will be dismissed.
No,
All right.
yes, must.
You are asking for an inquiry and then you are not cooperating. This after 3 weeks. All right.
Much obliged.
Yes, sir.
In this case, we need further instruction, therefore.
What is the matter, sir?
This relates to my lord, appointment of casual labor to work as temporary.
Casual labor to
Work as temporary.
what is the provision for that?
2000, state government has not framed any rules, but the Public Works Department has framed a rule,
Yes,
2006, my lord.
yes,
As per the rule, a merit list has to be prepared from the in-service casual laborers, my lord.
yes.
Thereafter, according to that merit list, first they have to be appointed as work as temporary, and only thereafter they will be appointed as work as permanent.
Yes.
The relevant rules, my lord, will find at page number.
Scheme, not the rule.
Sorry, scheme,
Page 19.
page 19, my lord. Relevant 28, page number 28.
This is for Public Works Department.
Yes, my lord, but followed by the other departments also.
No, your department is,
Water Resource Department.
okay. Where do we find that these are being followed?
My lord, I have made an amendment in my writ petition.
Yeah, in that case, we need affidavit, right?
Yes.
Or Mr. Aril Tungal, learning counsel for the Mr. Iriram, London. Additional senior government, praise for and granted 4 weeks time, 3 weeks time, 4 weeks time.
4 weeks.
File affidavit in opposition. This after 4 weeks.
Item number 23.
Non appears on court, non appears for petitioner on call. On 19/03/2024, also non represented the petitioner. MSK one London State Council is present. List after 4 weeks.
Floor 21.
Time for the all respondents.
Yes.
In fact, we filed, of course, that is not, this is still relevant. However, we filed the caveat petition before, in this particular matter. That has not been solved. Lordship has already issued a notice,
Who appears for
T. Tapak was the counsel for the other party, madam.
non appears for the petition on hold? There's an interim order also.
Interim, like, no coercive action, madam. There's nothing to be take any coercive action, madam. The contract agreement has already been terminated, madam. We are under process for, initiating the, for recovery of the amount. Risk and cost, the amount has to be,
That may also amount to coercive action.
So only because of that reason, we are not initiating
You
the,
file immediately for vacating the order. Right.
or otherwise, on maintainability also will argue.
Non appears for the petition on call. Mr. M. Katolanet DSJ is present. List after 6 weeks, 4 weeks.
Development.
22 matters, there was an interim order, matters.
Yes.
And I had gone to the PS, but the IO was on leave. And then the inspector endorsed, and after that, there's, I'll seek some more 7 days with the time, there's some intervening events, in his family. There's some ceremonies to be attended.
So in that case, you have to file an application.
Once I'll have
Is
a
that
look
it?
at this. I'll file, but 7 days he can appear. He had come, that was, IO was on leave, my lord. The inspectors endorsed that, my lord. Seven
What
days
is to
time
be
will be
done?
granted, my lord. If
Yes, your lordship, with that regard, they have to file an application before the IO. That's a different issue, your lordship. But in this bail matter, your lordship, we have not received the CD.
CD also can.
We'll continue the interim, will not say all
Yes.
these things.
Yes.
That's all. Not Mr. D. Gogoi, London Council for the petitioner. MSTG in the London additional PP, Samit said, is yet to receive the case diary.
Yes.
List this matter after 2 weeks.
My lord,
Interim-
kindly
interim
observe, my
order
lord,
was
if
earlier
the
shall
person
continue.
doesn't appear, my lord, he doesn't come, it may be cancelled, my lord. The
Huh?
petitioners are very. After getting, my lord, the kind of interim orders, my lord, after so much persuasion, they're like, oh, we'll go. My lord, kindly observe, my lord.
Within 7 days,
10 days, my lord. In 10 days.
it is submitted by London Council for the, it is submitted, the Mr. D. Gogoi has submitted that after the interim order of this court, the accused applicant has appeared before the investigating, where did you appear?
Or my lord, OC, the Itanagar PS, my lord. IO was
Appeared
on leave.
before the police station, on which the officer in charge has endorsed on the application, on the order of the, a copy of the order that since the IO is on leave. IO is what?
IO was on leave for training, my lord.
IO is on leave, IO is not available. Then what he has said?
He'll be contacted, my lord. The petitioner gave his numbers.
IO is on,
After that, there was.
IO is on training for a few days. The petitioner shall be, accused shall be asked to appear on an appropriate day. Considering the above, the accused applicant is directed to appear before the investigating authority within 10 days.
Well,
Failing which the interim order shall automatically Extend, well, cancel. How like? List after 2 weeks.
23, my lord, there was an interim order. My lord, the petitioner appeared before the IO on 1st of April.
Well, is anything there?
Oh, your lordship, it seems the complainant had not paid his due amounts, and therefore he had left the place of the complainant, your lordship. Your lordship, I don't have any objection if the bail is made absolute, otherwise, your lordship. He has been cooperating with the investigation.
Heard Mr. Ligo, the counsel for the petition. And also heard Mr. Keep it here. Also heard MS T. Learned additional PP for the state. This is an application under section 438. CRPC, 1978.
Sorry, my lord, the
For grant of
stepped in, my lord.
privilege
I
of
apologize.
arrest bail in connection with Yachuli PS case number 9 of 2013 under section 420, 380 IPC. Where's the FIR?
FIR is page number 15, my lord. Starts at 15.
Where's the allegation?
That the petitioner stole, petitioner was employed by the informant and he stole some things and fled away.
What something?
There's a, your lordship will find at serial number 4, your lordship.
Yeah.
Machinery, my lord.
The FIR, an FIR was lodged by the, who has lodged the FIR?
He is the
One Siri Joram Lely.
Joram Lely, my lord, his employer.
Bangan Lapang, opposite DIGP office, Ganga Itanagar. Alleging that the accused applicant alleging that the accused profession by carpenter for the construction of the for construction of his house at Itanagar and later at Joram village was engaged as a carpenter for construction of house at Itanagar and at Joram village. After full settlement of all his accounts for the works done by the accused partially, he approached for monetary assistance on the ground of illness of his wife, promising the complainant to continue his unfinished work at Joram village. Page 15, you just quote number 1, 2, 3, 4, and 5, huh? It is also alleged that the accused person has took advance the following so and so, huh? From the informant and has never turned up. Mr. The allegation, the aforesaid allegation includes the theft. Mr. The FIR was registered being Yachuli PS case number 09 of 2022, the section 420 of the 380 IPC. Mr. There is no recovery of the.
They have they have freezed his account, Your Lordship. And the items that there is no recovery of these items otherwise, Your Lordship. The items mentioned in the
The Mr. D. Learned counsel for the petition, accused applicant. What is your submission?
Well, the things are upside down. Well, the petitioner actually was given inhuman treatment, and due to his wife's problem, he has to rush back to Guwahati. And on the actually the informant owes him more money. Yes, madam.
The informant has misbehaved and ill-treated the accused, being a carpenter. And he did not honor his promise to pay the dues which he has for his work, for construction of his house at Itanagar and at Joram village. Mr. He submits that the accused applicant has never taken any, has never stolen any goods and never cheated the applicant, sorry, the informant, Mr. In any case, he submits that he's cooperating with the investigating authority, Mr. MST learned additional PP, well, has produced the case diary. There's nothing. How do we record? What is to be recorded?
Your Lordship will see the flag mark, Your Lordship. He has that's the statement of the accused, Your Lordship.
Accused.
Yes, Your Lordship.
On the perusal of the no, MS TG learned also learned additional PP while referring to the case diary. Submits that the matter appears to be a dispute regarding
Pending dues, Your Lordship. Pending dues, Your Lordship.
pending dues of the accused with the informant. who have been engaged as a carpenter for construction of house at Itano and at Joram. Therefore, there is no incriminating materials against the accused. Well, having considered the submission of land counsel for the parties and also the perusal of the case diary, it is it reveals that the accused was engaged as a carpenter by the informant, and there was a dispute with regard to the pending dues between the informant and the accused. And there appears to be a the allegations. No, there appears to be that there is no incriminating materials against the petitioner. This court on
19-3.
19-3-2023, 24. 19-3-2024. Granted the interim bail to the interim prayers bail to the accused person. Accused applicant contacted us in connection with the opposite case. Accordingly, the accused has appeared before the investigating authority and is cooperating. He appears to be cooperating with the investigating authority, avoiding the conditions as prescribed in the interim bail order. Accordingly, I deem it appropriate to grant the accused a privilege of pre-arrest bail. Accordingly, the bail order, interim bail dated 19-3-2024 is made absolute. Bail application is states order of disposal. Yes,
My lord, I am supposed to take steps upon respondent, man.
you take a step. So many times you have asked for. Heard Mr. M. Doji, learned counsel for the petitioner. The learned counsel for the petitioner is granted further 2 weeks, 3 weeks time to take 2 weeks time to take precise steps for service of notice upon respondent number 2. All the respondent.
1 to 3, man.
1, 2, 3. This after 4 weeks.
Obliged.
Your Lordship.
Yes, what is to be done?
I supposed
You
to
are
take,
supposed to take precise steps.
yes, Lordship, but I have taken.
So learned counsel for the petitioner is granted another further 3 weeks time to take steps for service of notice of respondent 2 and 3.
No,
This
Lordship,
after 4 weeks.
I had something to say.
Yes,
I had taken a step through PS Itanagar so many times, but they are failed to deliver the service, Your Lordship. So I have confirmed that they are serving in the NGC college. So I may be allowed to take dusty service.
precise steps by dusty mode. which will be routed through the registry. Within 3 days from today,
Yes, sir.
list after 4 weeks. What is it? MS so and so, huh? Learned counsel for the petitioner is granted 3 days time to take press steps through the mode, which shall be routed through the registry.
Last year, sir.
Then Mr. G. Tadolan, additional PP, is present. List the matter after 4 weeks.
Lordship,
Yes.
I'm also appearing for respondent number 5, who has newly been implemented as R5, Your Lordship.
Yes,
Director Narist. Narendra S. Narendra Nath S.
yes.
In respect of respondent number 434, we have already filed an affidavit in opposition, Your Lordship.
You are appearing now,
For all the respondents,
yes.
1, 2, 3, 4,
So
5 also. 5 has newly been implemented, Your Lordship.
you want to file affidavit.
No, Your Lordship.
So what is to be done?
Matter may be listed for hearing, Your Lordship.
Okay. It's a contempt petition. Well, this is for admission and we'll see.
Lordship.
Yes, madam.
Heard Mr. Parbi Yadav, learned counsel for the petition. MS NRG learned counsel submits that she has filed affidavit in opposition on behalf of all the respondents. List the matter after 4 weeks for admission here.
Obliged.
May I please come in? My lord, Dusty service is not yet taken. I may be allowed to take it, the steps again.
Mr. HK Jama, learned counsel, praised for and granted 3 weeks time, 3 days time to, 4 days time to.
My lord, it is in Dumporijo, even I have.
No, we'll list it after that. You will have to take the steps. Okay, Dusty.
Dusty.
Submits that, praised for and granted 3 weeks time to.
My lord.
Take Dusty mode, to take press steps through Dusty mode for notice of service of notice upon respondent number
4.
4. List after 6 weeks.
Mine.
MS
Highly obliged.
D. Riba.
T Riba
Or
4.
respondent number 3.
Respondent number 3 and
T. Ngomle, respondent 1 and 2.
respondent 2 and 3.
1
and 2.
1 and 2 are present.
Obliged, my lord.
This IA. Yes, IA for what?
Lordship, condonation. Lordship. Actually, Lordship, leading counsel, Mr. G. Kato is out of station, Lordship. He is absent, that is also signed, Lordship.
Who?
G. Kato, Lordship.
G. Kato.
Lordship. And this morning, I got the file, Lordship.
On the prayer of Mr.
K. Loren, Lordship.
K. Loren, learned counsel for the learned counsel appear on behalf of Mr. G. Kato, learned counsel for the applicant petitioner. List this matter after 3 weeks. Mr. M. Doji, learned counsel for respondent number, respondents is present.
Obliged.
Obliged.
Lordship,
Yes.
I am appearing on behalf of B.R. Das. for the
Award service
petitioner.
report. List after 4 weeks.
4 weeks. Obliged you.
My lord, here LCR has come, my lord. So matter may be fixed for admission hearing.
RSA.
RSA, man.
It is submitted to Mr. K. Tari, learned counsel for the applicant that LCR has been received. List of Mr. M. Kato, learned counsel for the respondent is present. List for admission hearing.
And my lord, IA,
After 3 weeks.
IA 07, there is interim order that IA 07 may be disposed of, my lord, by continuing till disposal of the RSA, my lord.
This court has, since I interlocutory application number 7/2004 has been considered and considered by this court and passed an interim order on 4/3/2024. The application is since disposed of. The interim order. No, interim order, if you are disposing of IA, it will be till, is it till returnable then?
It was still returnable there. Now that this IA can be disposed of till disposal of the RSS, my lord. Interim.
So once we dispose it of, it will be till disposal.
Then, my
Interim
lord,
order passed above shall be continued till disposal of the main appeal.
yes.
7 will be still disposed of, huh? Unnecessary it will use these are listed. Yes.
I'm sorry, Lordship. Lordship, there is an interim order in item number 32, CRP 31, Lordship.
30?
CRP 31, item number 32, Lordship.
Item, you tell me.
Item 32.
Interim order audio process shall continue. 32.
Lordship.
31 or 32?
Item number 32, Lordship. CRP 31, Lordship.
Yes. No. Item number 32. That will be, interim order will be in 33. CRP 26 or CRP 31?
Lordship, as per record,
CRP 31.
As per record, CRP
Interim
31.
order shall continue.
Lordship.
Lordship, I'm here for the petitioner. Respondent number 1 has filed the affidavit, Lordship. So this can be fixed for admission hearing, Lordship.
Or Mr. B. Jamal, consent for the petitioner. The appellant. Record has been received. And the respondent number, respondent have also filed, respondents have also filed that. List for hearing after 2 weeks.
Yes, 3 weeks, Lordship.
After 3 weeks.
Development. There is an interim, Lordship.
Interim order for us, they shall continue.
Yes, Lordship. Lordship, I'm appearing for on behalf of N. Rama, Lordship. And Lordship, the senior counsel of this case, N. Rama, was supposed to be present today, but
That's what is to be done.
Pardon, Lordship. Lordship, matter may be urgent today as the senior counsel is not present today.
Or Mr. So and so, learned counsel for the petition. Office news. No. Who face for listing the matter after 3 weeks? This after 3 weeks.
Applies.
Office note dated. No. Service report in respect of the respondent. Ever service report in respect of respondent number 4. This after 4 weeks.
My lord, I'll be filing affidavit within a week, my lord. This will list after 2 weeks.
Yes, sir. What is the matter?
My lord, this is regarding the appointment of, it's not appointment, my lord. The petitioner was entrusted as in charge of the midday meal at directorate, whereas his substantive post is a BEO, my lord. Later on administrative exigency, he has been sent back to his own post as a BEO. Now he's challenged by agreed of detachment of his charge.
Why you have detached? Let her continue.
My lord,
Let him continue.
because there's no midday meal nodal the in charge as such in the post, my lord. Now his substantive post is BEO, my lord.
Okay.
Block, my lord, his service is required there at the block level.
Who is respondent number 4?
Board respondent, okay. Deputy Director.
Mangal
Now,
Taki.
no, my lord. He's looking after the.
This is by name.
Yes, my lord, by name.
You have taken steps.
Yes. Step is complete.
Office note dated 06/05/2024 reflects that the service report in respect of restaurant number is still awaited. Mr. First write, or deposit learned counsel for the petition. Then you write this. Then next para, Mr. T. Tagum, learned standing counsel for health department. It's the
Education
education department. Praise for and is granted 3 weeks time to file affidavit in opposition. List after 3 weeks.
Deeply.
Record in respect of R1, R2, and R3 is still awaited. Record.
Lordship, the service report is submitted.
Ever service report. Miss Arthaku, MS Arthaku, Land Council Petitioner, and Mr. Jitado, Land Register PP are present. No, 42. This after 3 weeks. Yes.
I'm for the petitioner. Step has been taken.
When did you take this step? On 12th.
Yes. Party
12th January, 12th Feb. It's been 3 months.
I think all the parties appear.
You are appearing.
Yes, Your Honor, Your Lordship, I'll be appearing for respondent number 2.
Okay.
That is a private respondent. I couldn't get his signature in the Wakalatnama, but I'm representing him in the title suit which is in the learned CJM court.
Mr. T. Thorum, Learned Counsel for the petition. MS R. Basir, Learned State Council for
1.
For respondent number 1.
Respondent 1, yes.
Appears for respondent number 1, MS
I'm the LSC.
LSC.
Yes.
SB Darang.
My attendance may be reflected next day.
Learned LSC, Legal Aid Council. Enter the appearance of respondent number 2. Any affidavit needs to be filed?
Yes, Your Lordship, I need time.
Are you sure? Okay, LPC.
For cancellation of LPC.
Huh?
It's for cancellation of LPC.
The respondents are granted 3 weeks time to file.
Interim order may be continued.
Interim order is there?
Yes.
Interim order passed earlier. What interim order?
Cancellation of LPC here. Considering that LPC is dead, suspended.
Okay.
Highly all right.
Service report on R6 is available.
For respondent number 3, madam, we need some more time. We have not received the instruction.
But Mr. Deepang, Learned Counsel for the petition. David service report in respect of respondent number 6. Mr. P. Tapo, Learned Standing Counsel for Urban Development Department. Trace for and granted 3 weeks time to file. After 3 weeks. interim order plus earlier should continue.
Blessed.
Your Lordship, here also I need time for filing affidavit, Your
Yes.
Lordship. I'm for one, respondent number.
Service report, Mr.
B type.
B type with the learned counsel for petitioner present, award service report in respect of respondent number 2. MS Arbasar, London State Council, press for and is granted 3 weeks time to file affidavit.
Blessed.
No pleasure.
Lordship, in this case, with regard to this interim order, as
Yes.
per the last court order, this interim order, hearing for interim order was for, to be done today. Interim order is just with regard to community land. This is regarding compensation, land compensation. This community land has been assessed by this land assess compensation is board.
Your Lordship, may kindly take up this matter tomorrow, Your Lordship.
Next week,
For the next,
service report, Mr. T. Tapak, London Council for the petitioner is present. Then in that case, we'll take it after after 3 weeks.
with regard to interim order, because if a compensation amount is paid, there will be this irreparable loss.
We may direct for apportionment
Yes.
if you have the right. When we finally settle dispose of the matter,
Yes.
if you can establish
Yes.
you're right, we can ask for, even if it's paid, we can ask for apportionment. Right?
Because that is one thing, and
What,
another
what interim order?
interim order is
Land has already been acquired.
Interim order is
Land has already been acquired.
not acquired. That the survey has been done, but with regard to the petitioner, the land is, there is no proper survey.
Huh?
No proper survey. That is why we have made objection before the authority. If survey, that the compensation amount is finalized
Yes.
without proper survey, that will be a very,
This is for what?
this is for
Acquisition for what?
land acquisition for road construction, broadening of road, highway construction.
So what do you do? What interim order you want?
Interim order is the land compensation, this survey board has said, one is our land has been is recorded as community land, on one side. And on other side, our land has been not properly assessed. Accordingly, kindly see this.
What is private respondent?
Yes, private respondent,
Who else?
community land has.
Who else are entitled apart
Yes,
from you?
Some of the community land has been assessed in the name of land department, some of the staff of land department.
Huh?
Staff of the land department,
Very strange.
this
We'll see.
Mr.
Award service report in respect of respondent number 6. MS Arbasar, London District Council, press for listing the matter after a week. We'll see after a week. List accordingly. The list, praise alone, list the matter after a week. Who else are there? Who else are there? He's busy, he's busy. I think he's busy. Can you take up this? Yes.
This is
Plain paper.
yes, ma'am. The second page is electricity bill, ma'am, issued by the Department of Power.
Sorry.
Lordship, anyway, but I am not satisfied with this record because if she is staying in rent, generally sub-meter department used to issue. But anyway, if Lordship satisfied, can be transferred. No, otherwise, actually, this is not the proper document.
Okay, we'll allow. You be here.
No, no,
Write it out here only. It's good for the.
No, because,
it's good
because
for
of there
lawyers
is no
also.
proper address. That's why I have objected.
We'll record it.
If the proper, if it is a proper address in the very beginning itself, I would have not objected.
Yes, yes.
When there is no proper address, no jurisdiction. No. Minimum of, because if I have to file the suit before this UPA also, their minimum time is required to be staying in the particular area.
Yeah. Heard Mr.
T comes in.
T comes in, learned counsel for the petitioner, and also heard Mr. M. Bhatt, learned counsel for the respondent. By filing this application under section 24 of CPC, 1908, the petitioner has prayed for transfer of the matrimonial case within bracket Z, bracket clause number 01 of 2022, filed by the respondent for dissolution of marriage pending before the learned district judge 0 in the district of Lower Subansiri to the learned district judge UP Papumpare district, Arunachal Pradesh. The case of the petitioner is that she and the respondent has solemnized their marriage in the year 2014 as per the customs and tradition at Jiro and Dapurija, respectively. The petitioner belongs to Tagin tribe.
Yes.
And the respondent belong to Aputani tribe. They after their marriage, they were residing at Nacho in the Upper Subansiri district when the respondent was posted. He's a doctor.
Yes, he's a
he being a doctor. Thereafter, at Jiro, and finally at B sector, Naharlagun.
No, Lordship, that will be wrong because after Nacho, he was transferred to Dambuk.
Dambuk.
Yes.
So
After Dambuk, then Khunsan. He was never transferred to Jiro. Or
No, no, they have stayed together.
No.
At B sector also we stay. At B sector.
Anyway, if there is a dispute, we will not have to
Francis
stay
came, that means
Anyway.
1 or 2 days stay. That is separate issue. Otherwise, Nacho, Dambuk,
And Nacho,
Nacho and Dambuk. From Dambuk here.
according to the petitioner, they lived at they have resided at Jiro and at B sector Naharlagun also. Please do. after some years.
Yes, ma'am.
After the marriage, after some years as a husband and wife, both the petitioner and the respondent have not been able to continue the marital relationship, and thereafter they have started yes. For dissolution of their marriage, which has been registered as matrimonial case within bracket Z bracket clause number 01 of 2022 before the district judge 0 comma Lower Subansiri district. The petitioner, by filing this instant application for transfer of the case, seeking transfer of the above matrimonial case from District Judge UPR, District Judge 0 to District Judge UPR, on the ground that she being unemployed and resides and residing at Itanagar, initially at Naharlagan and now at Itanagar, is finding it difficult to attend the court of district judge at 0 due to her financial conditions. Please, what is your other prayer? What is your other ground?
Nothing.
That's all.
That's all.
Then your
Yes.
submission, Mr. No, then in this you record this submission, Mr. T. Kamsi so and so, huh? From this written submission argument, huh? From para 3 to 7. You record his submission and then we'll record your submission this much.
Yes. One additional
Yes.
lordship.
Just
because
wait.
Just,
Then
a few
on
points.
the other hand, Mr. M. But learned counsel for the respondent husband submits as follows, huh? Para 1 to you record all to 6.
Yes.
Ah.
And one
Then-
additional, Your Honor, because I have not reflected, because here only I reflected the law point, issue point. And one submission is that while he was posted at Dambu, they were reside together. And because respondent is a heart patient, kidney patient, yes, one kidney was transplanted. So when he has left for medical recheckup in Belor, petitioner has left the matrimonial house. That is a
Deserted.
government quarter from Dambuk. Since then, she never turned. That is there. I have been given in my affidavit.
Mr. M. But learned after this, huh? After this, further submits then. When the petitioner was posted, when the respondent was posted at Dambu.
That part already arguing
Huh?
In the maintenance case,
all right.
they were already.
It's his submission. Submits that when the respondent was posted at Dambuk
Yes.
and when he went to
Medical checkup.
medical checkup at Belo village.
Yes. Belor.
Belo.
Yes.
Belor.
Belor. Yes.
When he went to for medical treatment at Belor in the state of Tamil Nadu.
Yes, I think.
Tamil Nadu, right? Belor is Tamil Nadu.
Yes.
Belor. For his treatment, he been having a kidney ailment.
Yeah.
Kidney
yes.
ailment.
Kidney
Coma.
was transplant.
The petitioner had deserted
Yes.
the matrimonial home from
Yes. Dambu.
Thereafter, she never turned back
Yes.
to stay, to not back to the respondent, to stay, to be with the respondent as a wife. Thereafter, having no alternative, the petitioner has filed the above matrimonial case for
Yes.
dissolution of the marriage. And since the petitioner is a permanent resident of Zero
Yes.
at in the Upper Civil District, the court at Zero is having a jurisdiction, and since the petitioner is also a permanent resident of Dapurizha, the district court at UP has no jurisdiction. Therefore,
Then this 6 point we can add.
yes, just add that.
Yes.
Due consideration has been extended to the submission of the learned counsel for the parties. List of the respondent, whatever have been the reason, has instituted a matrimonial suit for dissolution of the marriage with the petitioner, which is pending before the district court at Zero, Lower Subansiri district. It is also placed on record that the petitioner, after separation from the respondent husband, was staying at Naharnagar and thereafter now stated to be living at Itanagar. And as a proof of such resident, the petitioner has submitted a certificate along with the electricity bill of the house where she is staying. Vista. Next one. In the case of Sumita Singh versus so and so, I'll give like reported in Air 2002, Supreme Court 396. The Honorable Supreme Court has held that the interest and the convenience of the wife has to be considered and accorded priority in such a case for transfer of the matter. In a case where the matrimonial case is being sought for transfer from one court to another. Please take. Next one. Having considered the facts and circumstances of the case and considering that the the petitioner is residing at Itanagar and who is stated to be an unemployed, though the respondent is a permanent resident of Zero, and at present, and being a doctor is presently posted at Honsa.
Yes.
This court is of the considered view that the matrimonial suit
Zero to transfer the matter to here. Thereafter, because it may take sometimes because.
Learned district judge is directed to send the
Entire case record.
the case, the matrimonial case along with the case records to the learned district judge at UPA.
Yes.
Should we give some time frame?
Yes, thereafter.
Within 15 days.
Yes.
Within 15 days.
1 month because.
1 month.
they will prepare.
Within a month, within 1 month, this stuff. Thereafter, the learned district judge at UPA shall, what is to be done? Shall pass appropriate orders
Yes, further proceeding.
from the date first to take up the matter.
Yes, yes.
Take up the matter from the stage where it was.
Yes,
From the stage of the matter at district judge 0. From the stage.
Yes, yes. That is only initial stage because not yet while only appearance they have done. Yes.
Okay, then I'll
Yes.
The present transfer petition states allowed and disposed.
Yes. Only one lordship petitioner may be directed to furnish the copy of the address.
Yes.
Because whenever the respondent take to steps because because I don't know the address. So
it is made clear that the petitioner shall furnish the actual address to the respondents.
Yes.
Respondent. So that no inconvenience is caused for issuing any notices in the proceedings.
Item 50.
Posted for hearing?
Yes.
It is already in the hearing list. Supplementary hearing.
In order. In order is
Item 50.
Hearing.
It's a supplementary hearing.
Oh, then matter may be next that I'm told that this.
What is the matter?
Is regard to conviction, 3 years conviction.
326,
The-
causing
it
grievous
is
injury.
Checking, this.
Is in jail
No, already
in bail.
in interim bail.
On the prayer of Lalit Council, joint prayer of Lalit Council for the petitioner, Mr. T. Tapak and Mr. G. Thado, Lalit additional PP. List this matter after 3 weeks. 3 weeks for hearing.
Mobilized.
And 51, huh? Huh? Anybody, item 51? Are you ready? Huh?
I'm ready, my sister ready,
Ready?
Dispose of the notes.
But then, Your Lordship, the private respondent is also there, Miss Labu. She's not present today, Your Lordship.
We'll see at 2.
My lord.
Yes.
In fact, my lord, if we could able to know the reason for absence of the council of the private respondent, the matter could have been mentioned before the break. I have confirmed over the telephone that the council appearing for the private respondent is suffering from high fever. For that,
High fever.
yes, for that reason only she unable to appear today. Therefore, Your Honor, my lord, in absence of the other councillor, so if this court ready to take up, then I have no problem. But despite of what I feel, my lord said, this will be in absence of the other party will be the futile exercise. Otherwise, this is the case of Basra case number 18. Where in the, where
304, part 1.
304.
So,
Your Lordship may fix this matter on any other date, Your Lordship.
high fever.
That I have been informed.
He sees MS Labu.
Yes, Your Lordship.
Gadi. Then when? After 3 weeks? 2
After
weeks?
3 weeks, Your Lordship.
No,
2 weeks.
no issue.
Married in jail? No. He's on bail.
In jail. No,
He's in jail.
Yes.
Heard Mr. C. Modi, Learned Counsel for the appellant. Also had MS. Is in Learned Edition PP produced. It is informed by the Learned Counsel for the parties for the appellant, as well as the Learned Edition PP. That MS El Lambe, El Gadi,
El Lambu, Your
El
Lordship.
Lambe, Learned Counsel appearing on behalf of respondent number 2, is having a high fever. Listed and leave the above. Let this matter be listed after 3 weeks.
3 weeks.
Can it be matter for 2 weeks?
2 weeks.
2 weeks.
After 2 weeks. List up to.
Dep-
List accord.
Item number 18, I forgot to make a prayer for extension of interim order. That may be kindly.
Item number
No,
8.
sir.